Good morning. Today we are going to discuss company audit. What is company audit? Company is the artificial being which separates entity from the owner or management. At the end of the period, company's financial statement must be submitted to the user after proper examination by the auditor. When an auditor apply auditing activities to examine the statement in order to give expert opinion thereon, such types of auditing activities are called company audit. Under the section 183 subsection 3 of the Company Act 1994, company audit means the balance sheet and profit and loss account or income or expenditure account, cash flow statement of a company shall be caused to be audited by the auditor of the company, as in the Company Act provided, and the auditor's report shall be attached into and the report shall be read before the company in company's meeting. A company is said to be an artificial person created by law having a separate legal entity distinct from its members. It cannot be directly managed by its owners because they are very large in number, having small holding and also scattered over a wide area. As such, the management and control of the affairs of the company is done by other persons, generally known as directors. But an absolute faith put it on the directors is not considered to be desirable on social and moral grounds. Moreover, the shareholders cannot know whether or not their investments in the company are safe unless the directors duly inform them through their reports. Hence, it becomes essential for a company to appoint an independent and qualified person, that is, an auditor, to verify and certify the truth and fairness of the financial statements. Further, the companies usually work with a large staff, and auditing serves a very useful purpose of locating all errors and irregularities in their work. Audit of financial statement. He must conduct complaints procedure to ensure the reliance he can place on the efficiency of the internal control system, to check various assertions of financial data reflected in P&L account for balance sheet. He must perform substantive procedure to check into the corrections, completeness and validity of the data. In addition to the above, the auditor assured that the transaction of the company do not violate the provision of Companies Act is as much as they get reflected in financial statements which he certifies. For this purpose, important provisions of Companies Act affecting the financial transaction of the company are presented in the chapter. The auditor has to see that the items of revenue, expenditure, and items of assets and liabilities to get reflected in P&L account and balance sheet as per the information requirements specified in Schedule 6 of the Act. He must ensure that the financial statements reflect a true and fair view of the trading results and financial status of the company pertaining to the period under audit. Now, appointment of auditor and appointment in under special circumstances. Section 210 and 211 of the Company Act 1994 deal with issue of appointment of the company auditor. Section 233, the Company Act 1994 deal with issue of appointment of order in a special situation. Appointment of auditor are guided by the Securities and Exchange Rules 1987. Provisions regarding appointment of a company auditor are as follows. Appointment of first auditor and appointment of subsequent auditor and appointment of auditor by a public limited company. Reappointment of the retiring auditor, appointment of auditor by government and appointment of auditor by government in a listed public limited company, and appointment of auditor in case of casual vacancy. Appointment of auditor and appointment in special circumstances. Appointment of first auditor. According to Section 210 and Subsection 6 of the Company Act 1994, important provision in this regard are follows. The first auditor of a company shall be appointed by the Board of Directors of the company. The appointment of the first auditor shall be made within 1 month of the date of registration of the company. The auditors so appointed shall hold office until the conclusion of first annual general meeting. If the Board of Directors fails to appoint the first auditor within 1 month of the date of registration. Now, appointment of subsequent auditor. According to the Section 210 and Subsection 1 of the Company Act 1994, important provisions are following. Every company at each AGM appointing the subsequent auditor. The auditor are appointed to hold office from the conclusion of the AGM unit the next AGM. The company shall within 7 days of the appointment give intimation thereof to every auditor so appointed. No person can be appointed auditor of the company unless his or her written consent. Every auditor appointed at annual AGM under within 30 days. Appointment of auditor by a public limited company. The public limited company enlisted with any stock exchange shall appoint a partnership firm of chartered accountants consisting of not less than 2 partners in practice for a minimum of 7 years, none of whom are associates in any way of the public limited company during the auditing period. Reappointment of the retiring auditor. Under Section 210, Subsection 3, at any annual general meeting, a retiring auditor by whatsoever authority appointed shall be reappointment unless the retiring auditor is not qualified for reappointment. The retiring auditor has given a company notice in writing of his or her unwillingness to be appointment. A resolution has been passed at the meeting appointed somebody else instead of the retiring auditor. Appointment of auditor by government. According to the Section 210 and Subsection 4 and to 210 Subsection 5, important provision in this regard are: if an appointment of an auditor is not made at the annual general meeting, the government may appoint a person to fill the vacancy. The company shall, within 7 days of the government power becoming exercisable, give notice of the fact of the government that is no auditor was appointed or reappointed. If a company fails to give such notice, the company and every officer of the company who is in the default shall be punishable with fine which may extend to 1,000. Appointment of auditor by government in a listed public limited company. Whenever the SEC deems it necessary to an audit in a listed public limited company, in the public interest, the SEC may appoint an auditor to do the audit within the specific time and to furnish the audit report to the SEC. If the listed public limited company fails to get its financial statements audited in the prescribed manner and fail to submit the audited financial statement within the prescribed time, the SEC may appoint the required auditor. Appointment of auditor in case of casual vacancy. Important provision in this regard is: the Board of Directors may fill any casual vacancy in the office of any auditor. Where such vacancy is caused by the registration of an auditor, the vacancy shall not be filled by the company in general meeting. An auditor appointed in a casual vacancy shall hold office unit the conclusion of the next AGM. Now, disqualifications of the auditor. A body corporate, an officer or employee of the company, a person who is partner or who is in the employment of an officer or employee, a person who is obliged to the company for an amount 1,000 taka or who has given any guarantee or provided any security in connection with the indebtedness of any third person. A person who is a director or a member of a private company or partner which is the managing agent or treasurer of the company, a person who is a director or the holder of a shares exceeding 5% in nominal value of the subscribed capital. And remuneration of an auditor. Under section 210 with the subsection 10 and 210 with the subsection 11, these are the sections explained about remuneration of auditor in that particular situations. And next, duties of an auditor. Number 1. To certify statutory report, to report to the members of the company, to inquire into particular issues, to certify director's declaration of solvency, to report the prospectus, to assist inspects, to assist the public prosecutor. And rights and powers of an auditor. Access to the book, account vouchers, obtaining information and explanations, inquiring into particular issues, receiving notice and attending the general meeting, reporting to the members, visiting branches and access to the branch account, signing the auditor report, receiving remuneration. And next, removal of an auditor. Removal of auditor before the expire of tenure. There is no provision regarding to the removal of auditor before the expire of his or her tenure. However, from various provisions can be identified in this regards. For natural reasons of death or incapacity, self-removed through resignation from the assignment of duties, for dishonesty or disqualification. Next, removal of auditor after the expire of tenure. According to section 210 with the subsection 6 and 210 subsection of 9 and 211. The first auditors of a company is appointed by the board of directors prior to the first annual general meeting. That's why remove to first auditors and appoint in his place any other person who have been nominated for appointment. The nomination notice has been given to the members not less than 14 days before the date of the meeting. An auditor other than first auditor may be removed from office before the expire of his term only by a special resolution of the company in the general meeting. The retiring auditor has the right to make a representation which may be circulated to the members unless it is too late to do so. Without prejudice, his or her right to be heard orally required that the representation shall be read out the meeting. Thank you.